Okay, welcome back everyone for our webinar. This is going to be a take two of our webinar for today. We are very honored to have Cornell professor Ms. Celia Bigoness and her team from the Entrepreneurship Law Clinic. We have Nicole Gould, Jennifer Chu, Saqeef Ahmad, and Nayanthika Ramakrishnan joining us today, all Entrepreneurial Law Clinic students. And I'm going to turn things over to Celia because we're a little bit behind now, but we're going to catch up post-haste.
All right, thanks very much, David. And we'll speed talk. So thanks again to you and your team for hosting this. And welcome everybody. I'm going to start to share my screen with you right now because we have a set of slides that we are going to run through today. Really, the purpose of our presentation today is to address what we're seeing as some of the most frequently asked questions and major issues that employers are talking about in light of the COVID economic crisis, falling into some themes of, for example, now that we're all working from home, how can we protect our privacy? How can I ensure a safe workplace if I or any of my employees are reporting to work in an essential business? How can I protect my employees? How can I keep paying them? How can I ensure that they have health care? Also, conversely, if I really am operating with reduced revenues, how can I control my costs and potentially cut payroll? And then a final set of questions around working with visa holders, so non-US citizens and non-green card holders, because there are some specific implications of the current crisis. So we are lawyers. We have put a lot of text on the page because that's what we do. So don't feel as if you need to take everything in that is on these slides. We will make these slides available after today's webinar. And within the slides are embedded a whole host of links for resources that you can look at yourself. So you don't need to get it all right now. You can have the slides after the fact. We also will likely not be able to take questions in the interest of time, but we will share our contact information for anybody who would like to share questions with us after the webinar today. So I'm going to hand over to Saqeef Ahmad, who's going to walk you through some employee privacy and safety issues for you to think about. And throughout these topics, we have addressed both existing law and the new ongoing changes that we've all seen through the Federal CARES Act, the Family First Coronavirus Response Act, New York sick paid leave, and various other federal and state laws and regulations that are coming out on what seems like an hourly basis right now. So we try to keep track of all that as it stands right now at noon on Friday the 3rd. All right, thanks very much, Saqeef. Go ahead.
Thanks, Celia, and thanks, David, for setting this all up. My name is Saqeef Ahmad. I'm a third-year law student at Cornell, and I'll be focusing on privacy and safety issues. So this area is primarily aimed at the HR personnel, HR teams for businesses, small businesses, employers, and so forth. So there's a few laws that come into play here. On the federal level, we're going to primarily deal with the Americans with Disabilities Act, the ADA. There's also a state version of this, the New York State Human Rights Law. So the bulk of our discussion will focus on the ADA and how to apply the ADA. There's also the Health Insurance Portability and Accountability Act, HIPAA. This only applies to HIPAA entities. So if your business acting in the capacity of a health insurance plan. So we won't be diving too much into this. Just a few considerations to keep in mind before we get started on looking at the ADA. A lot of the issues you're going to be coming across is, what can you ask your employees in terms of, are they feeling sick and so forth, in order to learn what the risks are and to protect your workplace. So when you're running through these situations and scenarios, just bear in mind that you want to protect the confidentiality of employees that are affected with the virus or have family members affected with the virus. You want to prevent discrimination and harassment, and you want to build a level of trust with your employees. They're going to remember, kind of how the business has handled the situation after this stuff passes. So you just bear in mind the big picture of maintaining a solid reputation as you're going through this. And sometimes you're going to have to use your best judgment because there may not be black and white answers. Okay. So generally under the ADA, medical inquiries or exams are prohibited. So basically, this is intended to protect employees against employers from eliciting information that can expose a physical or mental disability. There is an exception that can be triggered by two things. One is that if there is a direct threat, right? So if you have a reasonable belief based on objective evidence that one, there's either a direct threat due to that employee's medical condition, or two, because that medical condition impairs the employee's ability to perform the job. The latest CDC and EOC guidance has declared COVID-19 as a direct threat. So this should give you some guidance as to how to handle these situations. But what we'll do in the next couple of slides is go over, what can you ask and what you can't ask. Okay, so generally speaking, these are a few examples of what's allowed and what's not allowed under the ADA. One thing to bear in mind, I provided links at the end of these slides to the latest EOC and CDC guidance. Check this stuff daily, because as the situation evolves with COVID-19, what the CDC and EOC is advising employers to do is changing on a day-to-day basis. So for example, taking the temperature of an employee as they come into the workplace. This is generally prohibited under the ADA because it's considered a medical exam, but the latest EOC and CDC guidance actually permits this in the case of COVID-19. What's generally not considered a medical exam or inquiry, asking about the cold or flu or COVID-19 symptoms, like coughing, shortness of breath, and so forth. So there's several scenarios, several examples that you can run through. I provided links to these where you can kind of see what the issue that you're dealing with and see if it's allowed by, if the EOC and CDC say that it's okay to do, basically. Okay, so, as you're collecting medical information, in order to comply with the ADA, you really want to keep things confidential. So the EOC and CDC have, warned about this to employers, but the big picture is, one, you want to limit disclosures, keep things on a need-to-know basis. There are a few exceptions of under the ADA where you may have to reveal private medical information to government officials, to local health officials, and so forth. So there are a few exceptions, but for the most part, don't share this stuff with coworkers. You don't want to reveal the identity of an affected employee, even when you are letting, kind of preparing your workforce for potential risk. Never reveal the identity of the affected employee. And as you're collecting the medical information, keep this stuff in a separate file. Don't mix this up with your standard HR personnel documents. These are just steps that the ADA recommends you take in order to protect that value, or that private information. We understand a lot of businesses are transitioning to remote work, so there's several considerations to keep in mind. We've posted them up here, but a few things, understanding like timekeeping and overtime liability, for example. A lot of employees work a 9 to 5, they're hourly, not salary. So, but people end up working at odd ends of the night, especially as they're working remotely. So if you do, email an employee, text an employee after normal business hours, just bear in mind that you may trigger certain overtime liabilities. So, and another important area is data privacy. So, as employees bring home, laptops and so forth and start working more from home, you may have very confidential client information, privileged information on ongoing deals or so forth. You want to protect all of that stuff, work closely with, IT teams, like if you have an in-house IT team, or seek out some IT help. There's several ways to do this: data encryption, securing your emails. So there's several steps and measures that you can take to really protect this password encryption again. So we really recommend that you beef up the data security as you're transitioning to working remotely. And I've outlined a lot of the helpful resources that I use to, pull together this research. The two ones that you should really look into are the EOC and CDC guidelines, because they're the leaders on this stuff, so they're providing updates on a day-to-day basis. So and it's all very well organized as well. So If you ever have any questions, this should be the first place to go to. And so next we'll be covering employee leave, which will be covered by Jennifer Chu.
Hi, thanks, Saqeef. So again, I'm Jennifer Chu. I'm a third-year JD MBA student. Thanks again for joining us today. We're going to basically walk through those major pieces of legislation in response to the COVID-19 crisis that were discussed earlier, both on a state and federal level. Again, as this area of the law is very alive, and the government's continuing to publish further guidance and webinars, I really strongly recommend all participants to check the links embedded within this presentation at the end of this specific section for the most up-to-date information. So to kick things off, it's important to note that these legislations are both drafted slightly differently in terms of the definitions that they use. As we all know, New York State is currently on pause, so non-essential businesses are closed because of that executive order. This isn't different from the terminology of quarantine order that's used in the FFCRA, the Family First Coronavirus Response Act, in which case that quarantine order or isolation order has to be applied to this particular individual themselves. So it's important to note this as we move throughout this section, that there are going to be different exceptions and thresholds for each piece. So the New York State Senate Bill S8091 is immediately available to any employee who falls under these three categories. The first two are the new parts of the Senate bill. And then the last one is that there has now been an extension effectively because COVID-19 is now considered a serious health condition. So now that falls under that family care. There are some exclusions here. This excludes employees who can telework and don't show any symptoms. And it also excludes employees who have returned from voluntary travel from a level 2 or level 3 designated CDC country, not at the direction of their employer. It's also important to note that citizenship and immigration status do not affect the employee's eligibility for this leave. So diving into that first category for the quarantine employees themselves, as you can see that there's an approach tiered based on the number of employees and then also in terms of the amount of revenue. This shows the duration of paid sick leave, and it's measured in calendar days, not working days, and the benefits that are available afterwards. In this case, part-time employees will be entitled to the number of days and amounts during either applicable 5-day or 14-day calendar period that they are required to receive had the employer's operations continued as normal. Now moving on to the second category, employees are eligible for this paid family leave if their minor dependent child under the age of 18 has been quarantined. Much like the first category and really throughout this entire process, we should keep in mind that employees are entitled to the same rights of job protection, continued health insurance, and no retaliation in all situations here. It's important to note that there is a distinction between why the employee's dependent child's school has closed. So if it's a mandatory or precautionary quarantine order, isolation order issued by the Department of Health or the local Board of Health, then that would be likely eligible. Whereas if the school is instituted preventative social distancing, that is not the same thing. And again, you can check the link for the designated amounts and how to calculate that wage. And then finally, as I mentioned earlier, COVID-19 is now considered a serious health condition. So now this falls into this other provision that allows employees to utilize family care to take care of an eligible family member who has contracted COVID-19. The definition, as you can see online, includes domestic partners as well as parent-in-laws, and then anyone whom the employee has had legal custody. And we encourage participants to get a better sense and really follow the website guidance here. So at a federal level, this Family First Coronavirus Response Act, like I said, is very different from what has been offered in the New York State paid leave, as opposed to having that tier categorization. It's really looking at any business with fewer than 500 employees. In terms of counting those employees, this includes full-time, part-time, as well as day laborers from temporary agencies. employees on leave, and then, employees who may be jointly employed. Independent contractors do not fall into this 500 employee count. If that business, or if your business has a more complicated corporate structure, then there are a series of tests, which you can see in some of the FAQ, for whether or not that employee is counted into that 500 number. But most likely, if the entities are joint employers under this test, then all common employees will be counted. So as you can see in this slide, that businesses can apply for small business exemption, which we'll go through in a bit. So it's, as you can see, these are the qualifying conditions. There's 6 of them. There's kind of a bifurcation in terms of the level of benefits that are paid leave that's available. Some important things to note, that the qualifying condition number 4 here is much broader than what New York provides, as it extends employee care, that to anyone as opposed to an eligible family member. And then for qualifying condition number 5, which is very similar to the New York State version, it's important to note that an employee can elect to substitute any leave during this period, and that includes vacation leave, personal leave, medical leave, and so forth during the first 2 weeks of partial paid leave. I'll go into this further, but this is a key qualifying condition for that small business exemption from the provision of paid sick time or paid family medical leave. Again, as COVID-19 is an evolving crisis, the number 6 qualifying condition is really a catch-all, and that is going to be conditions specified by the Secretary of Health and Human Services. Like the New York provision, the part-time employees are included in this, and the calculation is going to be looking at that average hour, and during that 2-week period, you can also look back at a 6-month average, or look back at the agreed hours that the employee and employer had agreed to upon hiring. This also includes overtime hours. Generally, I would like to note that the right to work here under the FFCRA is generally available, but employers can still lay off employees for legitimate business reasons, and we would really encourage participants to look at the FAQ for more details. So onto the paid family medical leave. As you can recall from the previous slide of qualifying condition number 5, an employee can take a total of those 12 work weeks during that 12-month period. So it adds an additional 10 weeks of leave. It's a combination of the 2. And if the employer was already covered by the FMLA, which is a separate provision, employee may take the remaining portion available. So we again encourage participants to look at the FAQ for more details to calculate that total amount of leave. And finally, really just going through what are really best practices for employers. There is a notice requirement, which means that there's a actual poster that's been posted online. We have the link in this presentation that needs to be posted at the worksite. If the worksite is closed, then you can email those notices, ideally by April 1st. Obviously, because things are changing constantly, there is a temporary non-enforcement period really relevant to the entire FFCRA. So employers have until May 1st to comply with everything, including that notice requirement, as long as it's reasonable and good faith. So there hasn't really been any guidance for this small business exemption, which is really for businesses that have fewer than 50 employees, and that will exempt businesses from the paid sick time or the paid family medical leave if they qualify into qualifying condition number 5. There should actually be a webinar for further guidance posted sometime today. I don't know if it's, as of when it first started, it hasn't been posted, so maybe it hasn't been posted yet. But again, this also links to all those fact sheets available. We encourage and recommend that employers, take all the documentation necessary from their employees just so that they can have proof of that qualifying condition. And so there's also a series of things that you would need from the New York side in order to get that qualification of the isolation order for this process. But again, this is very much an open question and subject to change. So for the employers themselves, they're entitled to tax credits for the paid sick time and the paid family medical leave related to COVID-19. And this also includes the healthcare expenses. One of the ways that we recommend businesses that are really cash strapped is to request accelerated refunds if that payroll tax is not sufficient to cover the leave. Again, there's a form here with a link that employers should check out. So to kind of sum it up all together, the New York employee can receive the greater of the New York benefits or the FFCRA. So that's something that will need to be done on an employee-employer basis. It's important to know that all employers and businesses should be compliant with all of the laws. So in this case, if an employer has 100 to 500 employees, they must provide benefits under both laws. Again, to calculate that the difference between the benefits, the FFCRA has an 80-hour cap, whereas the New York quarantine leave from that Senate bill calculates everything by calendar days. And again, here are some helpful links I referred to earlier. Again, this is constantly moving, so it's really important to, as an employer, to reference these frequently. So now I'm going to hand it off to Nayanthika, I believe, who will be discussing employee layoffs and status changes.
Hi, everyone. Thanks, Jen, and thanks, everyone, for being here. So with the COVID pandemic and the economic downturn, a lot of employers are faced with the prospect of laying off employees, and this it triggers obligations for the employers under the W.A.R.N statute, which is both at the federal level and the New York state level. These statutes apply only to those entities that either have 100 or more employees at the federal level, or if it's 50 or more employees at the state level. And they require employers to provide advance notice to employees who are being laid off. Now, the triggering event for these statutes to become applicable is really layoffs that exceed a 6-month time frame, or a reduction in hours over 50% of an employee's usual time, which also lasts over 6 months. Right now, with the uncertainty surrounding the pandemic, it is really difficult for employers to estimate if their layoffs are going to last more than 6 months. And so to avoid future liability, which is quite steep under these statutes, it's in addition to back pay and benefits, there's also a $500 per day fine for each day of the violation, and which is capped at $30,000. But still a significant amount of money that an employer would have to pay if they are found to be in violation of the W.A.R.N Act. It's not clear whether the two exemptions that are available under the W.A.R.N Act, the natural disaster and the unforeseen business circumstance exemption, are available for the COVID pandemic, because the Department of Labor and the New York State Department of Labor have not yet issued clear guidance on this. There could be a case that even if an employer lays off employees today in the anticipation that it's not going to last beyond 6 months, but by month 4 or month 5, it looks like it's going to continue, it becomes that much harder to make an argument that this was really unforeseen. So as a best practice, it is probably advisable for employers to issue these notices to their employees saying, we don't think this is going to last more than 6 months, but nevertheless, to comply with the W.A.R.N Act, we're issuing you this notice. And if employers are thinking of that, it's advisable that they seek legal counsel and get these notices issued to their employees. The next obligation that employers continue to incur is under the Fair Labor Standards Act for wages and overtime pay for their non-exempt employees, and their pay obligations toward their exempt employees. For people who are non-exempt employees or who are hourly wage employees, they can be paid only for the hours that they work. So if there's a reduced work requirement from them, they needn't be paid their entire salary. But for exempt employees, even if they work for only 50% of their regularly scheduled hours under the statute, they would have to be paid their entire accrued weekly salary. So some ways that some things that companies could consider for exempt employees and the financial burden associated with the present economic climate is that companies could prospectively reduce exempt employees' pay across the board. This would have to be done in writing, and employers should also be mindful of the fact that there are salary thresholds for exempt employees, which is at the federal level, it's rounded out to about 36,000, and at the New York State level for counties other than Nassau, Suffolk, and Westchester, it's at about $46,000. So it's important that even if there is a pay reduction across the board, it doesn't fall below those salary caps, because otherwise they would become non-exempt employees. The other thing that employers can think about is if exempt employees have paid time off or vacation days that they have accrued, they could be first asked to draw down on that so that they are not, they don't have to come into work if there is no work, and the employer doesn't risk accidentally classifying them as a non-exempt employee. And the very last thing that can be considered if there is absolutely a need for an exempt employee to work some hours and the employer is not able to afford paying them the salary caps, is to classify them as a non-exempt employee, which means they would have to be paid at least at the minimum wage standards prescribed at the federal and the New York State level, and they would also be entitled to overtime payments if they work over 40 hours in a work week. And with the switch to work from home, there's also a question that many employers have about whether they have to reimburse their employees for the work from home arrangements. And again, there's no clear guidance on, there's no federal obligation, and the only FAQ that the DOL has answered about this pretty much just says that if the employee is required to purchase equipment that goes over and beyond what they would otherwise have, like an internet connection or a phone bill, like if they had to purchase another computer or a printer, it is important that employers are mindful that those costs do not reduce the employees' wages below the hourly minimum. But for those employers who proactively want to reimburse their employees for the cost they're incurring from their work from home arrangements, there is one route that has now become available after the declaration by the president that the COVID pandemic is a national disaster, which is under Section 139 of the Internal Revenue Code. Now, there are some advantages of using this route to reimburse employees because this would not count towards their income, which means it would not have to be that is exempt from federal tax withholding, would not have to be disclosed on a form W-2, and it's also a deductible for the employer. There are no caps under the Internal Revenue Code on how much how much money can be paid as a disaster relief payment, and all that is required is that it's a reasonable and necessary payment which is related to the COVID pandemic, and that it is not otherwise compensated by insurance. There's no requirement in the law that an employer would have to receive proof of the expense from the employees, but to avoid overspending and avoid fraudulent claims, it's always better and is recommended as a best practice to have a written policy that makes it clear who's eligible for these reimbursements, what is eligible for reimbursement and what is not eligible for reimbursement, and lay down caps if that is in the best interest of the company. So these are a few helpful links which have the Department of Labor's answers on how the COVID pandemic affects employers' obligations under the FLSA, and another one from the New York State Department of Labor on the New York WARN Act, and whether the COVID pandemic would count towards the unforeseen business circumstance, which they unfortunately do not really answer clearly, but it is worth taking a look at it for what it's worth. And with that, I will hand this over to Nicole.
I think this one's Jen.
Yeah.
I'm sorry, this is Jen. Sorry.
No worries. So thanks again, Nayanthika. So this section will really cover, it's pretty short, we're going to just cover some of those new benefits and expanded benefits available under the New York State Department of Financial Services, and new requirements that have been imposed on New York health insurers. So the DFS has made a special enrollment period in light of the crisis to allow for individuals to enroll in insurance coverage, through the New York State of Health, the New York official health plan, or directly through insurers. This open enrollment this time has now been extended to April 15th. So as an employer, this is something that you could, if relevant to your employees, should be aware of. And really, for the safety of your employees and customers and employers and such, should advise employees that costs related to tests of the COVID-19 diagnosis are now covered. There are now also additional expanded benefits through the expanded telehealth offerings under the New York directive, as well as the recently passed CARES Act. And this is, in this case, it should be important to note that this directive does not include coverage for subsequent treatment. It only includes coverage for diagnosis. And then finally, in light of the financial situation for a lot of businesses may defer paying health insurance premiums for the time being until June 1st, 2020. As mentioned earlier, employers are required to provide continued health insurance coverage during sick paid leave, unpaid leave, or paid leave absences. Again, the interplay between all these moving pieces, it's still, employers have to be aware of what would qualify as a triggering event under COBRA, and if so, the employer should follow those notice requirements. So in this case, one of the things that we've been seeing is that employees have been furloughed, or and that could trigger COBRA, could trigger a termination event. We really want to encourage all parties here to be transparent and flexible, given how incredibly difficult this is and how much this has really adversely affected everyone in so many different ways through this difficult time. And so what we've come up with here are a variety of avenues that the employee can work together to navigate the situation. Some employers should consider, for example, subsidizing that cost of COBRA for a period of time. And also to anticipate that there will be some difficulties with open enrollment issues or delay just given the circumstances. One thing would be because of the strict timing requirements, perhaps to give some flexibility with the notification of that termination event, or don't terminate the coverage immediately, just so that all parties can really make sure that they're in compliance moving forward. Again, to segue into the next part is that, if the employer does go out of business, then that group contract will terminate, which means that COBRA or any continuation will no longer be available, and employees will need to pursue individual coverage. What you're seeing here is really just the general guide to COBRA. This is not specific to COVID-19, but would be helpful for employers to reacquaint themselves. And with that, I will hand off to Nicole.
Hi, everyone. I'm Nicole Gould. I'm a third-year law student at Cornell. This portion of the presentation explains the changes to unemployment insurance benefits as it has been impacted by the CARES Act. So traditionally, unemployment insurance benefits involves temporary income for eligible unemployed workers. There are several eligibility requirements, such as needing to prove their recent work history, that the unemployment is of no fault of the worker, the person is ready, willing, and able to work, and is actively seeking employment. So the amount workers typically receive will range from $104 to $504 a week for 26 payments for up to one benefit year. However, as I will soon explain, these benefits have been extended by the CARES Act. So the Federal CARES Act includes pandemic unemployment assistance and enhanced unemployment insurance benefits, and I'll shortly explain what exactly this means. So pandemic unemployment assistance is a program that gives extended eligibility for individuals who are traditionally ineligible for unemployment insurance benefits, such as self-employed workers or independent contractors. Enhanced UI benefits increases traditional benefits to an additional $600 per week to all UI recipients and extends the time period an additional 13 weeks on top of the usual 26 weeks to a total of 39 weeks. Employers who have part-time workers filing for UI benefits will not have their employer account charged if the part-time worker claimant worked for the employer part-time during any of the 4 weeks before the unemployment claim, and part-time work continues without significant interruption and to the same extent as during the weeks immediately before the claim. So this is just a helpful flowchart that outlines the various scenarios that claimants might find themselves in, and it just shows what benefits they may be eligible to receive based on their status, and I'll go into further detail later in this presentation. So for any employees looking to file their unemployment insurance benefits, this is a short guide to the process. The link attached here provides helpful step-by-step filing instructions provided by the New York Department of Labor. You'll see here, those are just screenshots, really just guiding you throughout the entire process. Just important to keep in note that while approval generally takes 2 to 3 weeks, payments may be delayed due to a huge increase in recent filings. But most importantly, claimants should note that New York State has waived the 7-day waiting period for COVID-19 related claims, and so you should file as soon as possible. So now I'm going to explain the several different scenarios claimants might find themselves in and how to proceed based on their status. So if you're already approved for UI benefits, you don't really need to do anything special. Just continue to certify weekly and your benefits will be automatically updated to receive the upgraded CARES Act benefits if eligible. And if you are filing a new claim, you should file your UI benefits claim online to find out if you're eligible for the CARES Act benefits. If you were not previously eligible for UI benefits, you can check your potentially changed eligibility status for pandemic unemployment assistance at the link attached here to the slide to see if you're eligible for those CARES Act benefits. And if your 26 weeks of benefits are already used up, you should still try to file for unemployment insurance benefits because your benefits may have been extended by the enhanced unemployment insurance benefits to get that extra 13 weeks of benefits. As a last note, employers should keep in mind the potential costs of inaccurate or delayed filings, such as incorrect charges to an employer's account, increased UI rates in future years, or delayed benefits for workers really relying on those benefits. And the Department of Labor has some really great resources on their website where they've been constantly updating their guidance for claimants. And so if there's any additional questions, it's pretty likely that they can be found on one of those links I've attached. And as we mentioned before, it's a rapidly moving target. So that's one of the best resources to keep up with after this presentation. And then next, Nayanthika will take on the immigration law implications.
Thanks, Nicole. So for employers that are bringing on new employees, and this could be employees regardless of their citizenship status, they would have to do a Form I-9 verification, and recently there's been some relaxation of the need to do this physically, and employers can now complete this remotely via Skype or any other teleconferencing software. but it's important to note that this exception does not apply if the employer has any employees working at their physical work site. So that's something that could potentially be helpful to employers who are bringing on new employees during this crisis. And now for employers who are hiring H-1B employees, there are certain like unique problems that employers who don't have the financial wherewithal to pay their employees face, because their terms and conditions of employment of H-1B employees are agreed to in the LCA that's filed with and approved by the USCIS. So if even if employers are furloughing or laying off their other employees, they would not be able to reduce the pay or stop paying H-1B employees and still have them on the payroll. The only possible route is termination, which again requires a written notification to both the employee and USCIS with an agreement to pay the repatriation expenses for the H-1B employee to return to their home country. And there's also the work site that's been approved in the employees LCA might not be the same work site anymore because of the work from home arrangements. However, if the employee's home is within a 50-mile radius of their usual workplace, it would not trigger the need to file an amended LCA. But as a best practice, it is recommended that employers still go ahead and send the LCA notice posting to the employee to put up in their home workspace, which even if it seems ritualistic and almost silly if the employee is the only one who's going to see the notice, but it is still required under the rules to have a notice posted at the place where the H-1B employee is working. So yeah, I think that's all I have on immigration law implications.
Great, thank you very much, Nayanthika. And thanks again to all of you for joining today in take 2 of our webinar today. As I said at the beginning, this was an attempt to summarize in a short period of time a complex area of law that also happens to be a rapidly changing area of law right now. And so what we have done in the slides that we're going to make available to you is we've tried to summarize the relevant issues and also give you as many tools and tips as you need to be able to follow along in this area of law. So the PDF that we will share with you will include all of the links that we have talked about and a whole variety of other links in there. This is intended to help you navigate your way through this efficiently, because otherwise managing all of this could be a full-time job. And I know all of you have your own full-time jobs, which all of a sudden have become complicated by the coronavirus. So my website at Cornell is linked to from the description of this program online. I will also make sure that my email address is in the written materials that are available to you. And I would certainly encourage you to reach out if you do have any questions, either on what we have talked about today or topics that we have not yet discussed. I'm not sure if we'd be able to answer all of them, but we will answer what we can. And we would also hopefully be able to provide recommendations and resources for you if there are areas that are outside of our area of expertise. So thank you again, everybody, for joining, and particular thanks to Nicole, Jennifer, Saqeef, and Nayanthika, who have pulled this together in the last week on top of their law school work. And so we wish you all the best of luck, and we will do everything we can to continue to help you and our community as we move forward. So thank you, David, and to your team for organizing this.
Thank you, Celia, for being here. Before we log off today, just a reminder that this entire webinar, we will put up part 2, not part 1, will be available on the Chamber website and on the Chamber's YouTube channel. So be on the lookout for links for those going up later today. Additionally, just letting everyone know, the next webinar in our Business Readiness series will be on strategic planning for your business during the COVID-19 crisis, 3 to 4 months and 8 to 12 months out. That webinar will be taking place on April the 9th from 12 to 1. please feel free to join us. The way that works is if you register for this webinar on the Chamber website on our event page, you will be sent a link to the Zoom event as well as a password to make sure that we are ensuring proper security for all of our future webinars moving forward. So again, thank you all for being here. Thank you to Celia. Thank you for all of her students for the wonderful information that you shared, and we'll be sharing those slides as well. So you guys have a great day, and we'll be in touch and see you at the next one.
Thanks, everybody. Bye.
Bye.